Now we're going to talk about Chapter 10, which is Privacy and Internet Law. So in today's world, we give up a lot of our privacy when we share information online. So when we post on Facebook, LinkedIn, Twitter, whatever it might be, we have to think about how long that data will be out there and who has access to it. And an example I like to show in my technology classes is I have data from 1995 or so that's still out on the internet and can be found in the Internet Archive. Another area where we lose our privacy is in data breaches. So organizations suffer a breach and our data is then compromised and accessible to those who don't have access or shouldn't have access to it. Another thing is surveillance and discrimination by employers. So employers go and do surveillance on us when we're going and applying for a job. Not all employers, but some. And so they might go out and troll your Facebook profile, see that you are out having a contest of drinking some beer and acting, perhaps irresponsibly, and they might use that in a decision for their hiring practices. And then the last area here that's, I think, a big area of privacy is big data. And so big data is used for collecting information, analyzing it, and using it to better improve marketing to customers, among other things. And then the last area here is an emerging area, and this is called the Internet of Things, or IoT. This is things like doorbells and cameras and Alexa devices and things like that. Let's talk about privacy laws now. So the Fourth Amendment guarantees that we will not have unreasonable searches and seizures. We have a reasonable expectation of privacy subject to two requirements: an actual subjective expectation of privacy, and then society accepts that your expectation is reasonable. Now, privacy torts under the common law. There's a tort called public disclosure of private facts. So this is, I may not reveal any truthful but secret information about you. And this requires that the defendant make public disclosure. They disclose facts that were private. The facts were not a legitimate concern of the public, and the disclosure would be highly offensive to a reasonable person. Okay. Now let's talk about the tort of intrusion. This requires that the plaintiff must show that the defendant intentionally intruded upon the solitude of another and in a manner highly offensive to a reasonable person. Again, reasonable person. There are many privacy statutes. So the first we talk about is the wiretapping and electronic surveillance portion, which is the Electronic and Communications Privacy Act of 1986. And this is the statute that governs the unauthorized interception of or disclosure of your wire electronic communications. And there's a section called the Wiretap Act that governs your face-to-face oral communications and telephone calls. And then there's the Stored Communications Act section, which is governing the stored communications like email or voicemail. Now, it's important to note that the Wiretap Act does not protect every conversation. So you should read page 261 to understand the exceptions to this process. Okay. Page 262 talks about email and by extension things like voicemail, okay, social media profiles, etc. Now, there are also aspects related to foreign espionage. So we've got the Foreign Intelligence Surveillance Act, or FISA. This is a statute that governs the government's collection of foreign intelligence in the US. So most importantly, this is people who are located in the US but are communicating abroad. Okay. If that's the case, no warrant is required. Further details on page 263. Then we've got state statutes. So the first one we have is the California Consumer Privacy Act, or CCPA, and this just became effective a few months ago. Okay. This particular statute governs privacy in California. This is a topic of an entire course, okay? So it would be very wise for you to take a look at this act, go do some Googling on it to read more about it. But in a nutshell, it provides many of the same protections of the European General Data Protection Regulation, GDPR, that we'll talk about in a few minutes. but it governs the data collection, how data can be stored for you, etc. Okay. Other states have similar laws, but California's is the most strict in the US. And it's also important to note that CCPA can apply to companies that aren't even based in California. Okay, so it can apply even if you move your company out of state and don't do any business here. Other state statutes governing areas like reader privacy, privacy policies, PII or personally identifiable information, employee monitoring, and social media passwords. Next, we have the European Union Privacy Law, or the GDPR. This has been around for about 2 years, but there was a predecessor privacy regulation that was in effect for many years prior to that. This protects all data for citizens of the EU. It has broad applicability, and it's not restricted to companies that operate in the EU. So if you process EU data, you're subject to it. An example, I have customers in the EU, it's applicable. I have employees in the EU, it's applicable, even if I don't have anybody there. Data is anything that can be used to identify a person. Processing is anything that you do to that data, including storing it or collecting it. People have the right to order you to stop processing at any time. It gives people broad rights to their data. It requires processors to notify of data breaches, and the penalties are severe, up to 4% of your annual revenue for each offense. This is a big deal. And if your business that you go to work for in the future is not adhering to this, you may not be in business for very long. Now, unlike in the US, there's this idea in the EU that you own your data. Now, CCPA does protect in a number of ways similar to GDPR, but not quite at this level. I don't think that we're going to have anything like this brought to the US anytime soon, given our dysfunctional Congress, okay? But do you believe that the US should have this level of individual privacy protections? Start thinking about that, because that's going to be one of our discussion topics here soon. Now let's talk about internet or cyberspace law. So most of this material is in the book, but I'm going to talk about first the law of the horse. Okay? And the law of the horse is something that came about 25 years ago when the internet was first starting to be commercialized. Okay? And so there was this Judge Easterbrook who basically likened cyberspace law to the law of the horse. There was no area of the law called the law of the horse. The idea of horse law back in the 1800s and before then, if there was an issue involving a horse, so say someone is traveling in a horse and buggy and their horse gets injured on someone's property, then what kind of law would apply? There's no horse law. Well, property law might apply, or contract law might apply, or tort law like negligence. But there's no separate law of the horse. So that's the idea that Judge Easterbrook talked about. And there's a citation here. You might find this. It's in the University of Chicago's Legal Review. You might find this particular write-up. It's not a case or anything, but it's just a little bit of an article that this judge wrote. Now, this other person, Lawrence Lessig, he had a contradictory view. He agreed a lot of times with Judge Easterbrook, but he also viewed that there could be specifics to cyberspace. And so he dived into what cyber law might teach if it existed. And so that was a few years later in '99. Again, that's in the Harvard Legal Review, so you can go out and read the Harvard Legal Review. I believe that the library has access to those, but if not, you might find them online, okay? But he talks about the realities of cyberspace and all the different laws that apply. If you think about it, internet law can be very confusing. We've got, maybe John is in California and Sally's in New Mexico. And so which laws apply and what type of laws apply? We have everything from property law, whether it's physical property or intellectual property law. We have things like contract law. We have things like the Universal Commercial Code. We have potentially tort law, negligence, infliction of emotional distress, you name it. Okay, there's a lot of different things that fall into this particular area. So when we think about cyberspace, every time we do something online, there are a lot of unknown variables there. And that's why this area of the law is just changing so rapidly. Now, there are a few areas that our book talks about in particular. Okay, so I'm going to focus on those. But if you are interested in this area, and some of you did say you were, I highly recommend you look up these articles and read them because they're very informative. All right. Okay, so let's talk about the first area here, which is net neutrality. And so net neutrality is this idea that any traffic that flows over the internet should receive equal treatment. And so over the years, we adopted this net neutrality rule, but it was repealed. Okay? And now that it's been repealed, it's entirely possible that internet providers could prioritize their own traffic over other sites. So let's say, use an example, let's say Verizon. Verizon sells TV service, okay, to their customers who get internet. So if Verizon wanted to make their internet TV service more palatable for people, they could charge more for you to have access to Netflix. Or maybe you have access to Netflix, but in order to get Netflix traffic prioritized, you have to buy the Netflix bundle on your cable package. Okay, you can see where this could potentially go. Has it gone there yet? Not so far, but could it go there? Entirely possible. Okay. Now, the next thing here is user-generated content. So this is content that you create and make publicly available as an end user. I'm not talking about what Yahoo publishes or CNN publishes. I'm talking specifically user-generated content, Facebook posts, Twitter, etc. Okay. And so there are specific laws related to user-generated content that protect internet providers. Now let's move on to online speech. The First Amendment protects speech, even if it's really horrible, but there are always exceptions. Okay? So if there is defamation involved, then the law of defamation will apply, which we discussed in Chapter 8. Okay? The plaintiff must prove that the defendant communicated a false statement, which harmed your reputation. But opinions are not defamatory. Statements must be verifiably false, and anonymous speech is protected if it is lawful. Okay? The idea being that it would be an undue burden on an ISP to go figure out who actually said it if it's anonymous. Okay? Now, there are also these things called SLAPP, or strategic lawsuit against public participation, that try to silence critics. Okay? Most states have now outlawed these and have anti-SLAPP laws to curb this particular practice. Next is violence. So the First Amendment protects against offensive or outrageous speech, but it does not protect threats of violence against individuals. Okay? So if you threaten violence, then free speech doesn't protect you. And then the last area of this section is revenge porn. So this is actually now illegal in most states. And this is when you commit a crime of posting unauthorized sexually explicit photos of someone else or videos, okay, with the intent to embarrass. Now, with respect to the liability of internet service providers, I alluded to the fact that content, as long as an ISP is not the content creator, they're immune. And that's because of the Communications Decency Act of 1996, or CDA. This provided immunity for ISPs and websites. If you just provide a form that's neutral for information, then you are not liable for content that's posted on that platform. Only the content provider is liable. So the person who posted it could be liable, but Facebook may not be liable for that. Okay? Now, if a website operator breaks a promise or a contract, so in this case, let's say someone posted information on Facebook, and then there was a request to remove the information, and nothing happened, and then the company promised that they would remove the information, and then they didn't, then you might be able to bring a contract claim against the provider for not removing the information because you relied on them to their promise to remove the information. Page 269 has details of a situation involving Yahoo. Next, let's talk about consumer protection. So with consumer protection, the FTC, or Federal Trade Commission, regulates activities, okay, certain activities. Number one is unfair or deceptive advertising. So it's prohibited to use unfair or deceptive advertising acts or practices. Okay? This is also applied to online privacy policies. It does not require that you have a privacy policy, but if you have one, you must comply with it and it can't be deceptive. Now, other laws like the CCPA and the GDPR do require that you have a privacy policy, okay? But those apply in different situations. Now, there's also a requirement for truth in advertising as well, okay? Now, spam. This is unsolicited commercial email, okay? We all get it, it's very annoying. And there's a CAN-SPAM Act which regulates it but doesn't prohibit it, okay? And I can tell you from experience, a lot of companies don't follow the CAN-SPAM Act, okay? The Children's Online Privacy Protection Act, or COPPA, protects internet operators from collecting information if the child's under 13 unless they have parental permission, okay? And so this is very important. You have to comply with COPPA as a business, okay? And then cybersecurity, there are a lot of data breach laws that occur as well, okay? Data disposal laws with respect to how do you dispose of data when you're finished with it. And then there are also other agencies like the SEC that govern things like the financial institutions' usage of customer information.